Welcome to our webinar on Secure Jobs, Better Pay and Fair Work Act reforms. In this webinar, we'll be covering the changes that lawyers, company directors and managers within all types of organisations need to make now and in the future, in order to respond appropriately to these changes within the industrial relations landscape. Today's presenters are Ellie Bassingthwaite, Practical Guidance Senior Legal Writer who covers the employment module, and we're joined by Michael Mead, who's a partner at Kingston Reid. Both of them will be explaining the changes that have been made so far and the changes that are yet to come, and provide detailed guidance on how to advise clients and stakeholders in order to comply with these changes. I'll hand this over to Michael Mead, who'll begin his part of the segment. Thank you.
Thank you very much, Roxana. Look, as you said in the opening, these changes, Secure Job, Better Pay, the amendments as a result of that Act, are the most significant changes that have happened to the workplace relations landscape in over a decade. Obviously, there are some individual changes that Ellie will talk you through that, in fact, impact individual employees. And the things that I will talk about are the more collective issues in and around enterprise bargaining. Now, these changes are far-ranging and affect a number of different facets of the enterprise bargaining landscape. Effectively, what we'll cover today are 6 broad brush topic areas. So the variations that have happened now to the ability to terminate enterprise agreements after their normal expiry date, together with the sunsetting of zombie agreements. Those that practice in the area will be familiar with that term and how it's been coined to effectively describe types of agreements that were made prior to the introduction of the Fair Work Act. There's been a range of changes that will commence shortly in the main in relation to enterprise agreement approval process and changes to the Better Off Overall test. So it's really important to dig into those for those people that are viewing the webinar that have experience with enterprise bargaining or think that they might want to face into enterprise bargaining now as a result of some of the other changes that will happen to the legislative landscape. The powers that the Commission has in relation to resolving bargaining disputes, and also as it relates to protected industrial action, should that occur as a result of enterprise bargaining, have changed to varying degrees. And it's really important, once again, from a strategic perspective, to understand what those impacts are. So I'll spend a little bit of time talking about that. But finally, we'll kind of round it off by talking about the various bargaining streams. And the big area in relation to the way in which bargaining has changed conceptually is a broader access now to multi-employer bargaining potentially. And that may have some fairly significant impacts for not only those that are regular users of the enterprise bargaining system, so those that are familiar and well entrenched in single employer bargaining. There are impacts potentially in relation to how they might be subsumed into multi-employer deals. But also it provides, and we'll talk about this in some detail in a few slides' time, the potential for unions to gain access to employers who have not traditionally bargained by effectively trying to rope them into particular types of multi-employer agreements to once again create a broader web of enterprise agreement arrangements that apply to a range of employees, potentially in industry, geographical location, or where it can be shown that they have effectively a common interest. So those things are really interesting for IR practitioners, employment law practitioners like myself, because they do represent some really significant changes to the structure in which enterprise bargaining can be conducted, and what it means then from a strategic perspective in terms of how you go managing this potential new world order for your operations. And we'll talk a little bit about that as well. So the mechanics of some of the perhaps peripheral issues, but they do feed into some businesses' either day-to-day existence and also some of their strategic considerations. So now, as a result of the amendments that have been created through the Better Jobs, Secure Pay, Better, the inverse of that, the legislative amendments, there is an inability to effectively, in a practical sense, in my view, terminate enterprise agreements as part of a strategic play that might happen in enterprise agreement negotiations. It's become far more difficult to terminate agreements as a result of the way in which the test for unilateral termination has been reconstructed. It's a provision, the ability to terminate after the normal expiry date by application, which has existed in the workplace relations legislation for many years, and now effectively, instead of it being a test about whether it's not contrary to the public interest to give rise to that termination application, effectively there need to be a series of requirements that are satisfied. One is that effectively a continuation of the agreement would be unfair to employees. The second being it does not and is not likely to cover any employees. So if employees move out of an entity, that could be a relevant consideration. And the third is that, and this is one that really will affect employers who might be initiating the application, that the continuation of the enterprise agreement would threaten the business's viability, and therefore termination would reduce the risk of redundancy, insolvency or bankruptcy. So the paradigm under which those applications can now be made if you're an employer effectively shift to one where unless there is some core threat to the viability of the business as a result of the operation of the enterprise agreement, you couldn't really envisage that an application of that nature could be made and be successful. Now, another interesting part of the way in which those applications would be ventilated if a business was in fact making the application on the basis of a concern about its ongoing viability is effectively the employer needs to give a guarantee for employee termination entitlements. So in the absence of providing that guarantee, once again, the ability to have the agreement terminated, even if you meet that situation where the business is in a precarious financial position as a result of the terms and conditions of the enterprise agreement, would just not be available. Moving on to zombie agreements. So this might only affect a small number of people that are watching the webinar. And effectively, as I said in the outset, zombie agreements are these types of instruments that have existed pre-Fair Work Act. In some circumstances, they are made under the work choices legislation, so the previous iteration and variation of the workplace relations landscape prior to the Fair Work Act being created in 2009. Now, effectively, as a result of the commencement of the amendments, there's now a drop-dead date for those zombie agreements. So effectively any agreement that still exists as a zombie agreement has a notional expiry date. It will cease to operate 12 months from the date of commencement of the legislation. So we're talking about the 7th of December 2023, those zombie agreements will cease to exist. Now, the only way in which that sunsetting can effectively be delayed is by an employer or a party making an application to a Fair Work Commission to effectively seek to have it extended. And that extension could be a delay to the sunsetting for up to 4 years on application. Now, there's something that employers need to do within the next 6 months, so between now and the 6th of June. So if you've got a zombie agreement, you must notify employees that termination will occur and that the new provisions in relation to the sunsetting of zombie agreements will apply at the anniversary. Now, if you don't do that, there are penalties that will apply. So it's quite important for any businesses that have those instruments, not just to sit on their hands and wait for them to roll out of their operation, but they need to be thinking, first of all, what do I need to do now between now and the 6th of June this year? And then what might I want to do by way of a strategic consideration? If I do want the zombie agreement to continue, how do I go about making that application and under what terms might the application be granted? So getting advice in relation to that. And if not, you're happy to have the zombie agreement roll off, then I think the relevant considerations are, well, what are my employees then covered by? So what awards might underpin their conditions? What things do I need to know about from a payroll and compliance perspective so that, come the early weeks of December this year, 2023, I'm not in a situation where my zombie agreement has expired and lapsed. I don't know what I should be applying, and I've therefore got some compliance concerns. So, really important to start to get ready for that in earnest sooner rather than later. Look, around the making of enterprise agreements, so the idea of how they might be created and formed with your employee cohort. These are agreements that might be made now prospectively. There are some things in it that are useful for employers, both in relation to a relaxing of the genuine agreement test, and also, I'll talk about it in the slides' time, a relaxing to a certain degree of the better off overall test. So those are things that are positives, I think, for employers or users of the system that have kind of at various times probably met some of the structures within the pre-amended Act with some measure of frustration because, there were very prescriptive interpretations of what was required at various stages. So the access period, that concept has been removed from the legislation. So effectively, there is now a broader analysis that applies in relation to determining whether employees have genuinely agreed. The Fair Work Commission is also charged with ensuring that it issues a statement of principles that will support those who are trying to make an enterprise agreement to understand what are the considerations that the Commission will apply in trying to understand whether agreement has been genuinely agreed. So whether the vote that is carried by 50% plus one in order to have an enterprise agreement approved by a valid majority, whether that reflects genuine agreement in a statutory sense. So therefore, the enterprise agreement can be approved. There's some interesting facets of the genuine agreement test as well. So one of the things is that in the multi-employer enterprise agreement context, this idea of genuine agreement now interlocks with a notional requirement for a union who is a bargaining representative for employees to effectively approve the going to a vote stage of the agreement. So where some employers may have been bargaining with unions and ignored the desires of the union and then gone straight to the employees with a direct access kind of approach to getting the vote up. Under these new provisions, if you've got a multi-employer agreement, and there are a range of different multi-employer options that are in play that I'll talk about a little bit later, but if you've got that multi-employer arrangement, voting needs to be notionally with the endorsement of the union. There's also this idea that from a coverage perspective, for an enterprise agreement to be genuinely agreed, it needs to be sufficiently representative of the interests of the employees that it covers. Those who are familiar with industrial relations parlance would know that there's a concept of a brownfields agreement or a light brownfields agreement, where you might have a small cohort of employees, and this has been used by various employers previously as part of a strategic play to kind of make an agreement and have some stability, but do it with a small community of employees, as opposed to using a greenfields arrangement where you need to effectively reach agreement with the union. So the ability to have a light brownfields agreement now is going to be very, very challenging because, as I said, this idea of genuine agreement all hinges off whether, in fact, there is a sufficient interest and a sufficient representative cohort of employees that vote on the agreement as it relates to the coverage of the agreement. So the idea of having 5 employees that might cover one classification vote up an agreement when it covers 30 classifications across a wide geographical footprint, that's going to be problematic in the context of this genuine agreement test as it's being refashioned. So coverage will be very important as part of a strategic consideration. The other thing that's important from a strategic perspective is who can initiate bargaining. So, what the amendments open up effectively for anyone who is in the enterprise bargaining system already. So those that have an enterprise agreement, and even if one that's expired, if the nominal expiry date is within 5 years of the proposed initiation for new bargaining, effectively unions can start now to initiate the bargaining process. So where previously if an employer said, look, I don't really feel like bargaining at this particular juncture, I'm just going to wait. And it would then be incumbent on a union to effectively seek a majority support determination and convince the Commission that a majority of your employees do in fact want to bargain for a new agreement to get the ball rolling. Now, if you're already in the bargaining system, the union has a lot more power if it is a bargaining representative for your employees to effectively, by issuing you a notice in writing, shoot the starter's gun and get you off to the bargaining table, and then things like good faith bargaining obligations all then continue to or start to apply, which therefore means you're within the structure of the enterprise agreement provisions of the Fair Work Act, and there are obviously consequences for that if you continue to refuse to participate in negotiations. So, some of the conversations that I'm having with clients right now is all about, how the power has shifted in terms of when bargaining might commence. So questions about timing and when might be the right time to go and start your negotiations is really interwoven into some of the new considerations that underpin the changes to the laws. Changes to the boot, so I mentioned that. So This is one of the things, as I said, that looks to try and simplify and strip back some of the challenges that employers were having also with the Better Off Overall test. So effectively, whilst the boot has always been a global assessment, what we're doing now, or what the legislation provides for, and these changes will come into operation from the 6th of June, is that the Commission notionally is only to have regard to patterns or types of work that are reasonably foreseeable at the time the Better Off Overall test is being conducted. So having hypothetical rosters or rosters that aren't likely to operate within the employer's operation can't be a relevant consideration, or shouldn't be a relevant consideration. Now, the counterbalance to that is that there is the ability for the boot to be reconsidered over the life of the agreement if effectively the work patterns that were considered at the time of approval change in some way. So the idea that an enterprise agreement is an absolute locked box of terms and conditions once it's been approved, that has shifted slightly, because whilst we do get a little bit more relaxation in the Better Off Overall test in the way it will notionally be applied, there is then this ability for a party to effectively put their hand up and say, we think it now needs to be reconsidered because the things that we considered when the agreement was approved have moved in some way. That also goes to the powers of the Fair Work Commission in terms of amending a term in an agreement so it passes the boot. So relying on undertakings as a form of correcting concerns the Commission might have, now that's not part of the process, whilst the Commission is required to ask the parties, bargaining representatives, the employer, how concerns that they identify ought to be fixed or might be fixed. The Commission is not required to accept those views as its final determination, and instead, if it identifies a problem, it can then solve it in a manner that it ultimately determines is appropriate. So, one of the things from a practical perspective that employers, I think, really need to be doing is doing a really rigorous test of their agreement before they send it to the vote, because the last thing, in my view, that you want is to think that you've locked in a particular cost base by getting a yes vote with your employees. Then you get to the Fair Work Commission, they have a different view about what the Better Off Overall test looks like, and all of a sudden your cost base gets more expensive. And it would seem that that is something that is now taken out of your hands by virtue of their ability to make those amendments once you're in the system. And the other thing they can do is also fix errors, and that's something that has been enacted and is available now. So from the commencement of the legislation, fixing obvious errors in the enterprise agreement, for example, if you lodged an incorrect version of the agreement, that can also now be amended by the Commission effectively on its own motion. So a lot of movement to the mechanics of agreement making and also the process of approval. But for mine, as I said at the outset, the really interesting thing is the way in which the different frameworks, multi-employer bargaining, have been evolved. Now, I might deal with these in reverse order a little bit. So cooperative workplace agreements are a form of multi-employer agreement where effectively it's voluntary multi-employer participation. So it's very similar for those of you that are familiar with the previous multi-employer bargaining scheme. It's really similar to that. It feels very much like a rebadging of a very old concept. Supported bargaining, so too, there was a low-paid bargaining stream that existed under the pre-amended Fair Work Act, and it applied to low-paid industries and sectors, and effectively there's a structure to commence bargaining if you are an employer in an identified low-paid industry. So that is very similar to what this supported bargaining stream is. And once again, whilst it does exist, I'm not sure low-paid bargaining as a concept wasn't hotly used by a lot of employers or employees other than in some pretty narrow industries. So I don't know that it will impact a large swathe of employers. The one that I think will have the most potential impact to you is this new single interest bargaining approach. So effectively, whilst single interest bargaining as a concept existed in the pre-amended Fair Work Act, it was something that either required a ministerial declaration or the employer themselves to initiate it. The big change now is that unions can effectively identify some employers that they think are operating with a common interest and then seek to have them bargain on a collective basis with the union. So multi-employers, we're not just talking about one employer that might have multiple sites, but multiple employers that have this common interest can then be compelled to bargain together. Now, not only does that start the ball rolling, but once you've then got a commission making what's called a single interest employer authorisation, which is the kind of the foundation for then this single interest bargaining. Once that authorisation has been made, first of all, only a single interest in bargaining agreement can be made as an output for that, for employers that are roped into that structure. But also unions can ask for other employers to join in, to be joined to the application. For those old enough to remember federal awards from over a decade or 15 years ago, where employers used to get notices served on them from unions that created a bargaining dispute, and then they would be roped into a federal award to effectively fix that bargaining dispute if they didn't agree to those union claims. This is very much a version, in my view, of that. So the idea that multiple employers can bargain or be compelled to bargain collectively. And then once that has been established, other employers can be bolted on into it and roped into it in a way that perhaps undermines the concept of bargaining, because those subsequent employers don't really have a stake in being able to drive their own outcomes, other than trying to defend an application being brought in the Fair Work Commission to rope them in, and to try to argue either that there's not a common interest or there's another basis for resisting such an application. And that will commence, those provisions also commence from the 6th of June. Look, this slide just summarises kind of some of the key features of the various structures. I guess the really interesting things also in and around industrial action are that protected industrial action is available in relation to both the low pay bargaining stream, or what is the rebadged low pay bargaining stream, and also the single interest bargaining arrangements. There is, whilst a notional cohort of employers that might be able to fit into each of those groups, for example, in the low paid stream, childcare providers, and those that are traditionally in low paid industries. And this slide talks about franchisees as a cohort that might sit within single interest bargaining. Look, I think it could be far broader than that. So I think businesses need to be thinking strategically about how they manage those issues. And one of the things that I talked about timing earlier, one of the protections against the single interest bargaining authorisation and being roped into a single interest agreement is to have an enterprise agreement that is still within its nominal term. So I know that there are lots of employers considering whether in fact they should proactively seek to bargain with their employee groups so they have a little bit more mastery of their own destiny. Obviously, that's a strategic consideration that needs to be factored into any business dynamic, where you sit in the market and what your interests in terms of enterprise bargaining lie. But there are a lot of different levers that I think need to be considered and potentially moved as we start to manage some of these new structures. Look, just briefly, because I know I've probably taken a little bit more than my allotted time, Ellie, so I'm sorry about that, but quite interested with all of this stuff. So sometimes I can continue to talk ad nauseum about the changes. But look, in and around industrial action and bargaining disputes, I think the two really interesting things are that you've got this ability now for what are called intractable bargaining declarations, and then flowing from that intractable bargaining workplace determinations. That's a lot of words to just describe the ability for, in particular circumstances, the Fair Work Commission to arbitrate bargaining disputes. And whilst there'd been the ability for it to occur in narrow circumstances, if industrial action, for example, was threatening a section of the economy, or there was a serious broader consequence outside of the individual bargaining arrangement for arbitration, effectively now what we're dealing with is a temporal limitation. So if you've been bargaining for 9 months, or the later of 9 months, or 9 months after the nominal expiry date of your enterprise agreement, if you've got one, then at that particular point in time, if there's still no agreement that's been reached, there's no reasonable prospect of an agreement being reached, and it's reasonable in all the circumstances, the Commission can step in and make an intractable bargaining declaration, which then opens the door for them to be able to make effectively a binding determination in relation to the terms and conditions that will apply under that workplace determination, that intractable bargaining workplace determination. So a big shift potentially in the way in which strategy might be rolled out. In the industrial action space, there's also now a requirement effectively for mandatory conciliation in relation to once a PARBO, protected action ballot order application has been made and before it closes, to effectively come to the Commission and participate in conciliation if you're a bargaining representative seeking that action, so unions effectively, or employee bargaining representatives if they were pursuing that course. And if they don't effectively participate, then that effectively invalidates the action. So it means that the Commission will be more involved in trying to resolve and facilitate the resolution of bargaining disputes, and particularly those that reach the flashpoint of protected industrial action, without necessarily going through the steps of hopefully employers having to experience too much pain through experiencing industrial action to try to resolve any outstanding bargaining disputes. So look, that was a lot to cover, but hopefully you found that interesting. As I said at the outset, a huge amount in the collective space, but also a huge amount for individual arrangements for employees and the like. And I think that is my cue to pass back to you, Roxana, and Ellie will take us through that next section.
Thanks, Michael. You've raised some key points of consideration for employers and businesses as a result of the changes that we've had within the landscape. I'll just hand it over to Ellie to speak about her segment. I'll hand it over now.
Thank you, Roxana. So, as mentioned, I'm going to speak about the features of the Secure Jobs Better Pay Act that operate at an individual level. These changes will have the potential to affect a great number of employees and therefore a great number of employers. However, the effects are more localised and really focus on the employment relationship, so the relationship between the employee and their employer. My aim is to explain what impact these changes are likely to have on that employment relationship, to put these changes in the context of some of the other legislative developments that are brewing, and to highlight where organisations might need to take action in order to ensure ongoing compliance with the provisions of the Fair Work Act. So these are the topics that I intend to cover. So let's dive straight into the pay secrecy provisions. The Secure Jobs Better Pay Act prohibits pay secrecy clauses in employment contracts. It confirms that pay secrecy clauses in existing contracts are of no effect. It provides employees with a positive right to disclose or not disclose their remuneration, as well as disclosing or not disclosing any ancillary terms relating to their remuneration. And it protects employees from adverse action if they exercise their right to disclose or to not disclose these details. So when do these changes take effect? As you can see, some of the provisions have already taken effect. From 7 December 2022, employees are entitled to disregard clauses in their employment contract that might have otherwise prevented them from discussing their pay. When we speak about the right to discuss pay, it's important to note that we're also talking about the right to discuss any terms and conditions relating to the employee's employment that might be relevant to determining remuneration outcomes. So that means if you have two people employed on $60,000 per annum, but one is only required to work 35 hours per week and the other is required to work 38 hours per week, the prohibition on pay secrecy clauses will extend to allowing those employees to discuss their ordinary hours of work, as that's a factor that's relevant to determining remuneration outcomes. So these are the changes that have already taken effect. On the other hand, from 7 June 2023, the prohibition on the inclusion of pay secrecy clauses will take effect. Now, this is a civil penalty provision, meaning an employer can be fined for contravening this section, whether or not the employee has suffered any damage associated with the contravention. In terms of the action that needs to be taken to accommodate these amendments, 7 June 2023 is really the date that you need to be mindful of. Standard form employment contracts should be reviewed prior to this date to make sure that they do not contain any clauses that may fall foul of the pay secrecy provisions. On to gender equity in the workplace. The Act contains a number of measures that are intended to make good on the federal government's stated objectives to improve gender equity in the workplace. Some of these changes, like amendments to the objects of the Fair Work Act, are a bit more conceptual, while other changes, like those to the equal remuneration orders, you can really see where they might have some practical consequences. In terms of the amendments to the objects of the Act, the Fair Work Act has been amended as of 7 December 2022 to ensure that the promotion of job security and gender equity now feature in its objects. The objectives of the modern award regime have also been amended to require the Fair Work Commission to give consideration to issues relating to secure work and gender equity, and the minimum wage objectives now include the promotion of gender equality. In terms of the practical effect of these changes, these factors will now be matters that the Fair Work Commission must have explicit regard to in performing its functions under the Act. So, for example, when setting the national minimum wage, the Commission will now be required to explicitly consider how the amendments to the minimum wage promote gender equality. Similarly, a party who makes or opposes an application to vary a modern award will need to advance submissions regarding how the proposed variations impact on job security and/or gender equality in the workplace. As of 6 March 2023, the Act will establish 2 new expert panels in the Fair Work Commission, one for pay equity and one for the community and care sector. These panels will hear wage-related matters and help address issues relating to wages and workplace conditions in the care and community sector. The amendments confirm, in respect of equal remuneration, the amendments confirm that there is no requirement to adduce evidence of a reliable male comparator in order for the Fair Work Commission to make an equal remuneration order. Similarly, in terms of the work value claims, the amendments confirm that in determining whether to vary a minimum wages in an award on work value grounds, the Fair Work Commission's considerations must be free of gender-based assumptions. To illustrate why these amendments are important, it's useful to consider them in the context of a couple of cases. Firstly, the Independent Education Union's application for an equal remuneration order for early childhood teachers, which was determined some years ago under the previous regime, is a good example of why these amendments have a real potential to have some practical effects. Now, under the previous framework, the union was required to identify a male comparator group in order to progress its claim. Now, there was considerable difficulty in locating an appropriate comparator, and it led to a slightly absurd situation where the Fair Work Commission was asked to compare the work of early childhood educators, who were predominantly female, with the work of engineers, who were predominantly male. Now, the Fair Work Commission rejected the IEU's application on the basis that the engineers as a collective were not an appropriate comparator group. These amendments will remove the need to adduce evidence of a comparator. The second amendment confirms the approach adopted by the Fair Work Commission in the aged care work value case. Now, in this matter, the Fair Work Commission found that the work of direct care workers had historically been undervalued, in part due to gender-based assumptions about the skills exercised by those workers. Now, these amendments have the potential to take what I think are fairly described as seldom used provisions of the Fair Work Act and really turn them into genuine options for employees or unions who are seeking to address gender-based pay inequities in the workplace. Another space that I think will really be worth watching is how the changes to the equal remuneration process or a work value claim will interact with both the pay secrecy provisions that we just discussed and also a bill that has recently been introduced into the Federal Parliament that seeks to amend the Workplace Gender Equality Act. Now, in terms of the latter, the Workplace Gender Equality Amendment, closing the Gender Pay Gap Bill, which was introduced in early February 2023, aims to allow for the publication of gender pay gap data at an organisational level. Now, as it currently stands, gender pay gap data, which agencies or organisations with over 100 employees are required to report into the Gender Equality Agency, is only available by reference to certain factors such as industry or location, as you can see from these two graphics. Obviously, this affords a degree of anonymity to some organisations who might not be necessarily completely comfortable with their gender pay gap data being readily identifiable. If the government's bill passes in its current form, it's not difficult to imagine a situation where an employee might view the gender pay gap data of their organisation on the Workplace Gender Equality Agency website, confirm that pay discrepancy by speaking to their colleagues about rates and terms relevant to remuneration in their particular workforce, noting that the pay secrecy provisions in their employment contract, which would have otherwise prevented them from having those discussions, now no longer apply. And armed with that information, makes an application for an equal remuneration order through the Fair Work Commission. Now, the government's bill is still in its early stages, but this is definitely a space to watch for employees and employers. So on to the provisions relating to the restriction on the use of fixed-term contracts. Now, a note before we begin discussing these provisions, the term used in the legislation is fixed-term contract. However, the amendments will apply to both fixed-term contracts and maximum term contracts, the latter of which are far more common in the workplace. In terms of what has changed, the key features are as follows. Firstly, there's a limitation on the use of fixed-term contracts for the same role beyond 2 years or 2 consecutive contracts. This includes renewals, and it is whichever is the shorter period that will apply. If these rules are breached, the contract will still be valid, except for the term of the contract which provides for its expiry on a set date. This means that the contract will automatically convert to an ongoing contract of employment. The employer may also be liable for civil penalty provisions for breaches of these restrictions, and there is now an added requirement for the provision of a fixed-term contract information statement to employees who are engaged on this basis. There are 9 exemptions to the application of the fixed-term contract restrictions. So there are a fairly large number of circumstances where employers will still be permitted to use rolling fixed-term contracts where it's genuinely necessary and appropriate in the circumstances. Now, I would anticipate that the most commonly used exceptions are going to be those relating to genuine training arrangements, such as where the worker is engaged as an apprentice or a trainee, where there is a distinct and identifiable task, i.e. where the completion of a particular project might run over schedule and necessitate the extension of a fixed-term contract past the 2-year or 2 contract limitation. And thirdly, where the worker is a high income earner. So where the worker's annual earnings under the contract are above the high income threshold in the year that the contract is entered into. In addition to the restrictions, employers are required to provide a fixed term contract information statement to employees who are engaged on a fixed term basis. Now, this statement will be developed by the Fair Work Ombudsman and will set out details of the fixed term contract limitations, the exceptions, and also the dispute resolution procedure that will soon exist through the Fair Work Commission. In terms of the operation of the fixed term contract restrictions, these restrictions don't take effect until the 6th of December 2023, meaning they are some of the last provisions of the Secure Jobs Better Pay Act to come into effect. The delayed operative date is reflective, I think, of the fact that this is a significant restriction on a practice which previously operated without regulation. And employers will obviously need some time to review their operations against the new legislation to determine whether they can continue to incorporate fixed-term contracts in their hiring practice. Now, there's a little asterisk next to that start date, as the fixed-term contracts entered into prior to this date can be counted towards determining the overall term of the worker's engagement. So, for example, if you look at the timeline that we've laid out here, if a worker enters into a fixed-term contract with their employer on the 1st of July 2021 with a term of 2 years, and prior to the expiration of that date, it's extended for a further 12 months, then once the prohibition or the restrictions take effect on the 6th of December 2023, the clause setting the maximum term of that existing contract will still be valid, but the worker couldn't be offered another extension of the contract for the same role prior to it expiring on the 30th of June 2024, because by that stage, they've already worked in the role for longer than 2 years, having regard to the pre-commencement service. In terms of the action required between now and the end of the year, employers should consider reviewing their practices regarding the offering of fixed-term contracts and establish a process for assessing whether it is appropriate and permissible in the circumstances to continue to offer fixed-term contracts to employees in the future. An essential step in this process must be the provision of the fixed-term contract information statement to employees who are engaged on this basis. Now, there have also been a number of changes to the Fair Work Act that have the effect of conferring additional powers on the Fair Work Commission to resolve disputes regarding flexible working arrangements, unpaid parental leave, sexual harassment disputes in the workplace, and discrimination claims in the context of a general protections application. Considering the amendments to flexible work and unpaid parental leave, as a refresher, the right to request flexible working arrangements is an entitlement under the National Employment Standards that is currently available to select employees, including those who are parents of school-aged children or those who are aged 55 or older. Under the current provisions, the eligible employees are entitled to make a request, and employers are entitled to refuse a request for flexible working arrangements where there are genuine business grounds for doing so. A similar situation exists in relation to extensions of unpaid parental leave. Eligible employees are entitled to request an extension, and employers are entitled to refuse the request on reasonable business grounds. After June 6, 2023, the amendments will require the employer to discuss the requests with employees and proactively advance alternatives to the request that would accommodate both the employee's personal circumstances and the employer's business interests if the employee's request is not able to be accommodated. If there are no alternatives that the employer could advance, the employer will be required to identify that. The amendments also provide an easily accessible process for challenging an employer's decision to refuse a request for flexible working arrangements or an extension of unpaid parental leave through the Fair Work Commission, when previously the Fair Work Commission only had a very limited ability to review such refusals in the past. In terms of the action required, employers should review their policies and, when necessary, update their processes for responding to such requests. Critical steps will include ensuring the request is discussed with the employee within 21 days of receipt, providing a written response to the request also within 21 days, and where the request is refused, ensuring that the response details the reasons for the refusal, the changes in the employee's working conditions that the employer would be willing to accommodate to allow for the employee's specific circumstances, or specify that there are no such changes. And it also needs to identify the avenues that are available to dispute the employer's decision. Employers may also wish to familiarise themselves with the dispute resolution process through the FWC, although we expect that further details will be made available regarding how the Fair Work Commission intends to handle such disputes closer to the commencement date of these particular provisions. In terms of the changes regarding sexual harassment and discrimination in the workplace, the Fair Work Act will now expressly prohibit sexual harassment at work and will provide employees with a new way to deal with sexual harassment disputes through the Fair Work Commission. The amendments will allow the Fair Work Commission to deal with sexual harassment disputes through conciliation, mediation, or consent arbitration. These changes will take effect from 6 March 2023, so they're right around the corner. The Fair Work Commission has recently published an implementation report detailing how it intends to manage its expanded jurisdiction to deal with sexual harassment disputes, and that implementation report is well worth a read. There are also changes to the provisions relating to discrimination in the context of a general protections application. From 7 December 2022, the Fair Work Act now includes specific protections for employees and prospective employees against adverse action being taken against them because of their gender identity or intersex status, or because they are breastfeeding. Now, these changes just bring the Act into line with changes that have already been made to Commonwealth anti-discrimination legislation over the years, so they shouldn't require too much action by employers. From 1 July 2023, the threshold for access to the small claims jurisdiction of the Federal Circuit and Family Court of Australia will be increased from $20,000 to $100,000. This is really significant. Previously, if a worker had an underpayment claim where the amount claimed was more than $20,000, they would either have to reduce the quantum of their claim or they would lose access to the benefits of this jurisdiction. These changes will significantly expand the number of employees who are able to access the small claims jurisdiction of the Federal Circuit Court and Family Court of Australia. Now, as if these changes weren't enough to keep everyone on their toes, there's also a host of other amendments in the works under the Secure Jobs Better Pay Act and through other separate pieces of legislation. As a very quick recap, the Fair Work Act now prohibits the advertising of jobs with subpar pay rates, meaning pay rates that are lower than the rate in the applicable award. There have also been amendments to the Commonwealth Safety, Rehabilitation and Compensation Act 1998 to streamline access to workers' compensation for firefighters covered by the Act. In terms of the other legislation, paid family and domestic violence leave is now an NES entitlement for businesses with 15 or more employees. And for employees of small businesses, that entitlement will take effect from 1 August 2023. From 12 December 2023, employers or persons conducting businesses or undertakings will be under an enforceable positive duty to take reasonable and proportionate measures to eliminate sex discrimination at work. And to top it all off, the federal government is gearing up to introduce its second wave of industrial relations legislation in 2023. So it's looking like it's going to be another busy year for employers and practitioners in this space. Roxana, if there are any questions?
Thanks, Ellie. You've highlighted some real transformative changes in regards to employee rights, in particular with the gender pay gap data and also the fixed term contracts. Now we move on to our next segment in regards to questions and answers. We'll start with Michael. So Michael, you raised some quite insightful aspects of the single interesting bargaining stream and how it will operate in practice. What industries do you think will benefit from these?
Yeah, look, I think it's a really interesting question. In terms of, I guess, benefit, where do I see it? What industries are likely to be touched? Look, I think aviation is one where I can imagine there would be some keen interest, particularly given the outsourcing that's happened in that industry and the way in which unions like the Transport Workers Union and the ASU have been quite critical of some of the airlines in relation to their outsourcing of particular functions and services, some of which are matters that are going to proceed to the High Court later this year. Look, I can imagine that these provisions might have some impact on the way in which bargaining happens in that sector, whether it is beneficial to the travelling public and aviation carriers, that's a different question. But I think, Roxana, the really interesting is, where are these? What types of industry and what types of employers are these provisions likely to touch? Aviation, I think, would be an obvious one. I also think if you're an employer, just generally, that is sitting, probably towards the upper end of, the curve in relation to your wages and conditions outcomes, that you might be a reasonable target for a union to try to get you involved in a single interest employer agreement, because if you can find a way to get it, your conditions grafted onto other employers, then it does get wages moving. It does result in an easier way, in my view, for unions to bargain. They don't need to now organise at a local level. Instead, they need to identify the people that they want to be part of this community of interest, and then convince the Fair Work Commission that that community of interest actually exists. And if they can, then they are, off to the races, as they say, in relation to getting a multi-employer arrangement in place. So I think those are the reasons why I think all employers of all shapes and sizes need to be conscious of these provisions and start to plan for how they might strategically manage their operations and their workplace relations, industrial relations risks.
Thanks, Michael. And just off the back of that, do you think the amendments in respect of industrial action will change the way employers operate in regards to responding to that? And if so, do you think the responses will change under the new regime?
Yeah, so look, I'm going to say something controversial. I think protecting industrial action is going to go down as a result of these provisions, and particularly the intractable bargaining disputes provisions. Once again, my view is that now unions have leverage with employers that are different to the traditional forms of leverage, which is we will disrupt your business, and therefore by the way in which we take protecting industrial action or impose bans or limitations on the way in which your operation works, you will then need to meet our enterprise bargaining claims and demands, because we have become an inconvenience or a disruption to your business that is untenable. Now I think, given that after 9 months of intractable bargaining, a bargaining representative can go to the Fair Work Commission and say, well, look, we want you to sort this out and arbitrate the bargaining dispute. It means that employees don't need to go through pain. Employers don't necessarily need to go through pain, and instead, if one party was using this as part of their strategic, kind of game plan, they might just decide to put it in the hands of the third umpire, the independent umpire of the Fair Work Commission, and try to get terms and conditions that they think are more favourable than they could ever get an employer to agree to, or an employer getting their employees to agree to if they needed root and branch change in their operations. So I don't think industrial action in itself is going to be the main game. I think I'm more interested to see how quickly unions and employers in some contexts want to pull the trigger on letting someone else outside of their business just determine the bargaining outcome.
Thanks, Michael. It's interesting to see how these implications will kind of develop with time. I'll head back to Ellie, and I've got a few questions in regards to mainly the first one about an expansion of the Fair Work Commission's ability to deal with sexual harassment disputes. Do you think this replaces any existing avenues that are available to the employees in order to address this in the workplace, or do you think this would be a separate avenue altogether?
The amendments confer an entirely new avenue on the Fair Work Commission to deal with disputes regarding sexual harassment. So this is an additional option that exists or will exist and will be available to employees, in addition to the claims or applications that can be made under the Commonwealth anti-discrimination legislation, as well as the applications that are available to employees under state-based legislation. It's also in addition to the Commission's current powers to make anti-sexual harassment orders. So employees will now have quite a few options where they are faced with a dispute involving sexual harassment in the workplace in terms of how they're going to address that dispute.
Thanks, Ellie. I had another question to you in regards to the restrictions of the use of fixed-term contracts. Do you think these restrictions are likely to be enforced, and how likely do you think that will be?
The restrictions will definitely be enforced, but there are a variety of enforcement measures that are built into the legislation. So firstly, there is the measure that requires employers to, I guess, empower employees with knowledge about the relevant restrictions on the use of fixed-term contracts through the issuing of the fixed-term contract information statement. Now, this statement will be developed by the Fair Work Ombudsman, as I mentioned, and it also includes, it will include notice to the employee about how they can potentially resolve a dispute that might exist in relation to a rolling fixed-term contract situation. There are also civil penalty provisions that are built into the Fair Work Act, where an employer might contravene the restriction on the use of fixed-term contracts, as well as anti-avoidance provisions that prevent, for example, an employer ending one fixed-term contract, waiting a set period before engaging the employee on another fixed-term contract for substantially the same role. So the combination of those three factors, the provision of information, the civil penalties, and extending those civil penalties to the anti-avoidance provisions will be how the restrictions on fixed-term contracts are ultimately enforced.
So thank you both for this session. I'm sure following the session, employers and lawyers, they'll know how to deal with these challenges and I guess the impacts of such changes, considering how significant they are. So thank you for both your insights and also expertise in providing advice for such clientele. Thank you.
Thanks very much.